Well, I'll go ahead and get started. 10 o'clock. I'm Dane Ciolino. I am a 1988 graduate of the law school, and I currently teach at Loyola University Law School. I've been there since 1993, longer than I'd like to think. So I've been teaching there for quite a while. I teach ethics there. I also teach criminal law, procedure, and evidence and trial advocacy. Those are my big courses. I've taught over here several times. I'm teaching criminal law over here in the spring, so I'll be back over here too. So what I want to talk to you about is ethics. I predicted I would have 4 people here, and there are 4 people here, just like I predicted. Well, she works here. She works here. So, yeah, so I've done this speech every year on alumni weekend, maybe the last 5 or 6 years. And we have between, some years we've had 10 or 12. And I don't know why I felt 4 today, but 4 was about what I expected. So what I'm going to talk to you about is recent developments in legal ethics. And please, since it's only 4 of us, interrupt me if you want to talk about something else. I'm happy to talk about something else. We could do this any way you want, but what I'm going to do is just kind of go off of my blog, which is here, which is it's called Louisiana Legal Ethics, that I do with my, we're going to get ads, it looks like. It is a blog that I do. I used to do it by myself for years and years, but about 2 years ago, I got a partner in my private law practice, which is all ethics related work. You could guess what that is: lawyer discipline, judge discipline, lawyer fee disputes, lawyer disqualification motions, legal malpractice, basically all things lawyer law. And so she has taken the task mostly of keeping this up to date. And but I still do some posts as well. What it is probably once a week we post something new, and it's some kind of new development that we think would be of interest to lawyers in general and Louisiana lawyers in particular. So things like ABA ethics opinions, cases of lawyers behaving badly, lots of those. Informal ethics opinions from other jurisdictions. New York City Bar Association, for example, does a lot of other state advisory opinions. We essentially summarize here. And then we do the discipline in Louisiana. Every time a lawyer gets reprimanded, suspended, disbarred, permanently disbarred, we'll write a little bit about it. So if you're interested, there it is. You can take a look. So what am I going to talk about first? Well, we're going to scroll down to kind of the more recent posts. This is something that comes up in our practice occasionally. Lawyers want to put in their engagement agreements that they have authority to handle claims in a certain way. We have lots of first party. How many of you all are from Louisiana? 2 of you. Well, we have hurricanes here, and we have lots of first party insurance claims with people suing their own insurance company because the insurance company didn't fix the roof, didn't fix the sheetrock, you name it. And there's a lot of advertising by lawyers for that. I mean, it's everywhere, the ads. So we've got a lot of work arising out of the advertising and also arising out of how these lawyers want to handle these claims. They're very high volume claims. So sometimes one of our clients wanted to put in the engagement agreement that they had authority to settle for a certain amount. Once they kind of debrief the client, they figure out what the claim is worth. They want to get authority right then and there from the client to settle the case. Well, there are ethics opinions, and there's a recent ethics opinion from August out of the New York State Bar Association, or the New York City Bar Association, that essentially says, yes, it's okay to get advance authority to settle a case as long as the client's giving you that authority with informed consent. I mean, the consent's got to be informed, and if it is informed, then it's okay. Well, that's true kind of generally. Hello. Judy.
Hello, Dane. How are you?
How are
Sorry,
you? No, that's right. That's right. We're going to mark you present from when it started. Haven't seen you in a while. You all right? You don't need ethics. You probably.
I love listening to you.
I know, but you probably give ethics speeches all the time.
I think it's wonderful you're doing this.
Well, good. Well. So, this is kind of part of our research for answering this client's question. We wanted to put this in the engagement agreement. And most jurisdictions seem to allow it, which kind of surprised me a little bit, seem to allow it as long as the client's consent is informed. They have enough information to make a decision about whether to give you that advanced authority. Louisiana, however, has a different rule. Louisiana had rule 1.8K says that you cannot get advanced authority, a mandate or a power of attorney to settle a case from a client in advance. And you can't get settlement authority to even endorse checks or to sign settlement releases and settlement documents in advance. You just can't do it. It's a categorical rule. Now, not many places, other jurisdictions do that, but that's Louisiana's rule. So the New York City opinion is not much help to Louisiana lawyers. It's interesting because it says that you can get that authority, but if things change, you've got to go back because the client might not have enough information to make that decision. So those of you who are interested in getting, now this is the other issue that comes up. Suppose you get a settlement offer from the defendant for $100,000. You call the client. You want $100,000? I'll take it 7. You settle the case. Right then and there, you can get your client's authority to endorse checks and to sign settlement documents. Now, defendants are going to want the plaintiff to sign the releases generally. But you can get that power of authority. And a lot of our clients want to do that because they don't want the client to have to come in twice. This is this kind of, clients are not very sophisticated, particularly when you're talking about personal injury, car crash clients. And this is the problem. You're in a car crash. You say, okay, Dane, settle my case for $30,000. I go off and settle it. Settlement checks come in. I say, okay, you have to come in and endorse the check. And then I say, you come back in about 7 days for the check and clear the bank. I can't, you look at me, and this is what clients really do. They say, well, lawyer, why don't you give me my money today? You're trying to steal my money. So, well, no, I've got to put the check in the trust account. It's got to clear. And once it clears, then when it clears and the money's got, I'll write you your check. A lot of clients get really angry at their lawyers about that. And lawyers don't want angry clients. So what the lawyers want to do is get the client's power of attorney to endorse that check when it comes in. So the check comes in on Monday. The lawyers don't even, they've got the power of attorney. They don't even have to tell the client, right? They endorse the client's name. They put it in the trust account. A week later, they call the client and they say, come on in. We're ready to give you your settlement money. So then the client comes in only once, gets their check. Sometimes they get a little baseball hat and they smile for a picture and put on the wall. And then the client takes the client check out to the liquor store and buys liquor and then gambles the rest of the way. And they're happy.
Oh, that's pretty simple.
Well, I know. I shouldn't be cynical, but there I am. So there it is. So the happy clients, happy lawyers, that power of attorney is okay. And I do recommend that people do that, particularly when you've got a big, high volume practice. I mean, not that most lawyers do, but
Sign your name or you sign the client's name?
I would sign it, Dane as Ciolino as agent for client so and so, and then deposit it in my trust account. Let it clear, 7 to 9. I think the Fed clears these checks in 3 or 4 days, but I always tell clients wait 7 days. Because I had a nightmare scenario once. This was, I mean, imagine this. It was a settlement check for $300,000. The lawyer got the client to come in, deposited, client endorsed it, deposited it in the trust account. And the lawyer said, the lawyer had a lot of money in the trust account. I mean, like $800,000. wrote a check to the client. Client went that day and cashed the check. Lawyer was thinking, no big deal. I got $800,000 in there. It's going to clear. And 2 days later, the insurance company went into receivership, and the money was gone. The lawyer had to eat, got pennies on the dollar, but had to eat more than $200,000 worth of that because the lawyer didn't wait for the check to clear. So you just got to wait for the check to clear. Also, the Office of Disciplinary Counsel takes the position that you are converting other clients' funds, which you are, right? Because if right now you go cash that check, that's other clients' money that's going out to this client. So you can't do that. All right, so those are just a few thoughts on that one. I'm not going to bore you all with this, but the Louisiana legislature has been amending judicial recusal standards. They did it last summer and they did it again this summer, which is kind of somewhat interesting to me and my partner Claire, because we probably have 4 or 5 recusal issues, motions come up every year. But the one interesting thing that they did do, because we get this question a lot, if I submit a Judiciary Commission complaint against this judge, can I then move to recuse the judge? Because then the judge is going to be very angry with me because she's going to know that I submitted this complaint against her. So how can I ever get a fair shake before this judge once I submit the Judiciary Commission? Well, a lot of people were submitting Judiciary Commission complaints and saying, oh, well, now she's got to recuse herself because I submitted a complaint against her. Trying to kind of bootstrap a complaint into a recusal. Well, the legislature made it clear, at least in the comments, not the legislature, but made it clear in the comments that a Judiciary Commission complaint is not a basis for recusal. It's got to fit into one of this. There are a number of categories in Article 151 that permit recusal, and that's not one of them. So it makes logical sense if you think about it, but lawyers always say, well, how can I get a fair shake? Sorry. I always tell the lawyers, just wait to file a complaint. You've got this ethical obligation under 8.3 to report a judge who's committed judicial misconduct. You've got that ethical obligation, but it doesn't say when you have to do it. And also it's qualified by your confidentiality obligation to the client under 8.3. So, excuse me, under 1.6. So I always say, if you really think you need to submit that complaint, just wait until you're done, because it's really just going to make things worse. Okay, let's see. This was interesting. This lawyer actually called me to represent him, and I told him no. This is a lawyer who, well, I'll show you exactly what he did. Well, his name is David Band, because it's in the hearing committee report. He's an older lawyer in New Orleans. He's been practicing. They all know him. I kind of remember him from around the courthouse when I was a law clerk a long time ago. But what he did is he was getting on social media, Facebook, and also email, and sending emails to the opposing litigant. Saying things like, why don't you wear something low cut to trial? And he used some curse words in there too. And so the client told her lawyer that David Band was contacting her, sending these notes to her on Facebook. And he said that, well, of course, Rule 4.2 says we cannot contact a represented person unless we get the consent of that person's lawyer. So he said, I didn't know that she had a lawyer. Well, the mens rea for a violation of 4.2 is actual knowledge. I was on the committee drafting these rules for Louisiana back in the 2002 timeframe. We had thought about changing the standard to know or reasonably should know, kind of subjective or objective knowledge standard, but it's a subjective standard. You have to actually know the other party is represented in order to violate 4.2 by reaching out and contacting that person. So long story short, he said, I didn't know she was represented. But in some of these emails he wrote to her, he mentioned her lawyer. So again, just a stupid defense because it had no basis in fact, and he lost. And he's in the system now. He's early in the system. In September, what's it, October? Yeah, 6 weeks ago, the hearing committee report just came out, so he's got some more time before sanctions imposed. But long story short here, obviously the takeaway is don't communicate with represented persons.
Just ask. I guess this is a new case.
And he really knew, but he did it anyway. The ABA recently came out with a new opinion. Did you see it, Judy? A new opinion on 4.2, which I disagreed with actually. And I think there was some dissent. Yeah, there was
usually so. Dissents on the committee.
Yeah, you don't really see many dissents.
In written dissents, I mean.
Right, and I thought the dissents were right. This is the opinion. The question was, if you are a lawyer and you are pro se, essentially, you're representing yourself in a claim, can you call the opposing party to talk about the case? Can you essentially, when you know that they have a lawyer, can you call the opposing party? Well, we all know what the rule is for just parties. Parties are always free to talk to one another, even if they both have lawyers. Parties can always talk to one another. In fact, a lot of times we, as lawyers say, yeah, if you could work it out with them without their, please do. The lawyer will step back and let you all try to resolve it.
I've had judges actually say to me, because of some personality issues maybe going on, are you okay? And I'm like, I'm okay. And the other side's going, I don't know. And I've let parties talk, just in the context of a court. So
yeah, and
it's crazy, but it's
so the rule is that parties can talk to one another. So the ABA opinion addressed the question: what if one of the parties is a lawyer? Does that change things? Well, the answer should have been no, it doesn't change things. But the ABA says, yes, you cannot do that if you are a lawyer. Why is that wrong? Well, because a lawyer, you have to look at the rule 4.2. Rule 4.2 says, in representing a client, a lawyer shall not contact a person represented by a lawyer. In representing a client. Very important. The ABA opinion, the majority says, well, you're representing yourself. Well, no, you're not. You are yourself. Right? Remember, lawyers are agents. Much of lawyer law is a subset of agency law. And agents are people who go out in the world and transact business for a principal. Well, if you are yourself, you are the principal, you are transacting business on behalf of yourself, you are not representing yourself. You are yourself. That's why I think the dissenters were right.
Yeah, I think that they focused on is that you can never take off your lawyer hat, right? That's what they're kind of going with. It's unusual because it did have two written dissents on it. I immediately thought I'd tell you about hurricane claims and how many lawyers have individual hurricane claims, and there's an insurance company. I just disclosed that I am, but there's an insurance company who has lawyers, right? And you're dealing with an adjuster.
Absolutely.
So you need to get permission now, right? To go before you even talk with that adjuster. Do you need to get permission from the?
If you believe the ABA, the answer is yes.
Conversation. It's fascinating that there were two dissents.
Yeah. So
I'm not sure.
that a lot of people overlook that first clause in representing a client. A lawyer shall not contact a represented person. So that's just one context where I think the ABA committee has ignored that prefatory clause. This is a call I get all the time. Hey, a lawyer just scooped my client from me. I've been representing this client in a personal injury claim for the last 6 months, and now all of a sudden they're talking to another lawyer. Doesn't that violate 4.2? Well, no, because when the other lawyer is talking to your now former client, they weren't representing, they weren't doing it in a representative capacity. They were doing it in the capacity of, I want to scoop this client. They were doing it for themselves, right? They were trying to get a client. Now, of course, all the anti-solicitation rules apply. If there's the lawyer is banging on the door saying, hey, hire me, fire him, then that's a solicitation problem, but there's no 4.2 problem. And so 4.2 is kind of misunderstood. That's why a lot of people have 4.2 questions, and this is a 4.2 case that kind of straightforward, actually, but there it is. He also said, he said, I don't give a use a fuck. What's a use a fuck? You ever heard that term before? I don't even know what that is. Oh. This one I like. And you almost hate to call out names, but this is Maury Hicks and the district court, Maury Hicks in Western District. He's in Shreveport. He's kind of a stickler on many things. And I think a nice guy. I mean, I've done CLEs with him as recently as last year. But the reason he kind of comes up on my radar screen a lot is if you were a lawyer in the Western District and you are suspended reciprocally because of something that happened in the state system, he forces all of those people to go to a hearing before the magistrate in Alexandria, which is just really kind of nobody else does it. This circuit doesn't require it. The Eastern District, Middle District is you're in Louisiana, you come back. Maury Hicks requires a hearing of everybody. Great expensive delay. But this is what Maury Hicks did in this case. A lawyer was upset because Maury Hicks had been sitting on a motion for summary judgment for almost a year. We've all been there, right? We've all been there. What do? You call the judge and say, hey, what are you doing? I'd like a ruling. What are you doing? This lawyer for the plaintiff wrote the law clerk. And it really wasn't even that bad of an email. It was just kind of like, when can we expect a ruling? It's been a long time. We're trying to figure out, things that I would never say because I'm just scared to do that. But the lawyer just kind of said these things. Maury Hicks called her in, and as she walked in, he said, I'm sanctioning you for what you've done. You have belittled my law clerks, and that's unacceptable. And he imposed sanctions. I forget what it was. Might have been $1,000 or something, but he sanctioned the lawyer right there on the spot. The lawyer appealed to the Fifth Circuit and won, because the Fifth Circuit said that violated due process. You cannot sanction a lawyer without the two prerequisites for satisfying due process: notice and an opportunity to be heard. She had neither. She walked in and was sanctioned. Boom, right then. So there it is, and it was remanded. This just happened in August. I haven't seen anything on the remand yet, but the court didn't comment on the merits, whether or not this was an appropriate thing as a matter of substance. It just said as a matter of procedural due process that it was inappropriate. Good for the Fifth Circuit there. You all probably saw this in the ABA Journal. This is something that came out back in the summer. This was a defense lawyer, who handled a medical malpractice case representing a gastroenterologist. The opinion of the jury comes back exonerating the gastroenterologist. He goes back to his law office. I think it's in Los Angeles. Goes back to his law office, and they have a big party that afternoon. And during the party, he said, yeah, this doctor was negligent, could be, but we convinced the jury that other people in that operating room caused the perforation of the colon. How about that? And everybody's laughing. Well, meanwhile, somebody was recording it on their camera and posted it on social. Then the plaintiff's attorney got it shared it with the judge in a motion for a new trial, and the judge grants the motion for a new trial. So the takeaway, of course, on this is that, you know, you've got to watch what you say wherever you are nowadays because of social media, and whether this lawyer is going to be disciplined for what he did, who knows? Who knows? What he did probably violated Rule 1.6, which is his obligation of confidentiality to his client, because he was talking about confidential client matters in a way that was where he didn't take reasonable measures to protect confidentiality. Now, the ABA changed Rule 1.6C. The older I get, I'd say recently, but it was probably maybe 12 years ago, something like that, to include a provision that says you must undertake reasonable efforts to protect the confidentiality of your client's information. I like it because it told me that you don't have to take kind of uber protective efforts. You can store documents in the cloud. I mean, you just have to exercise reasonable care, which is a good standard, right? It's the one that you would expect. So I took that opinion and was telling lawyers for years, you know, don't worry about the hacker who might want to look at your interrogatories, just exercise reasonable care. That's the standard. Well, it also means that you have to exercise reasonable care. And I think, you know, like any objective standard, it changes with the times. And in these times, with social media the way it is, you've got to be especially careful what you say. Now, we in our law offices should be free to talk to our staff about our cases and not worry about it. This was an office party, and people had their phones out and they were recording while he was talking. That's he didn't exercise reasonable care. So I do think that he violated 1.6 by doing what he did.
I mean, obviously, I'm not right, but it seems to me that what he was saying was abuse of the legal system too. I mean, I can't stand what he admitted to.
I hear you. I hear you, but you know, lawyers. Oh, you know, what if a criminal lawyer was saying, "Oh, my client's guilty"? You say, "Oh, I mean, has a lawyer ever said that before?" I don't like it either. But the problem there is that it's a confidential, he's revealing confidences. And it's okay to tell that to your paralegal or your associate, like, "Oh, God, this guy's guilty, you won that case. Good work, guys." In the confines of your office, that's fine. But if you're at a party, you know, at Superior Grill drinking margaritas, and people, that's a 1.6C violation. Yeah, but your discomfort, I like your discomfort because it suggests maybe an 8.4 conduct prejudicial to the administration of justice problem. Maybe. Just doesn't feel right. I'm with you. But at least there is a rule that he did probably violate 1.6C. So I don't know if he's going to get disciplined for this. He probably will. There's too much media attention to it. But again, it's just, you just keep going back to, you never know who's reporting. Now, you know, I'm not a war storyteller generally, but I represented back in the last December a judge out of Lafayette who some of you might have seen. She used the N-word in describing a burglary that had happened to her house. She came home after picking her kids up from bars, and they pulled in the driveway, and there was a burglar in one of their cars. Her college-age sons jumped out of the car, wrestled the guy to the ground, and she yelled, "We've got an N, caught an N." And then she's looking at her home videos with her kids the next morning and saying, "Look, we caught an N, we caught an N." And her son was recording it on his phone, and he shared it on Snapchat with some of his friends. Now, he wasn't trying to get his mom in trouble. He was saying, look, we caught a burglar. Look, and this is us. This is the video of him on the TV screen. But in the background, you can hear the judge using the N-word. again. So once that was on social media, she resigned because she has African Americans who appeared before her that would never believe that they were getting a fair shake. So she resigned fairly quickly, in about two weeks or so after that it was made public. Which I thought was the right thing for her to do. She thought it was the right thing for her to do, and so did everybody else. So that was it. Now, that was it in December. Afterwards, I go back to Loyola to teach my ethics class, starts the second week of January. And I got a bias complaint against me because I was representing someone who was a racist. At least that's what they said. Yeah, my first bias complaint. And I had to go through a reconciliation process of the bias
Was
complaint.
it university based?
Yes. But to my dean's credit, she met with these students and she brought in judges and told them he's a lawyer and this is what lawyers do. We want to leave them alone. So I went to my first class, and this was actually at my dean's suggestion, why don't you make the first class about representing unpopular clients? Okay, good idea, Madeline. So I did, and I opened the class with emails that I received from white racists saying she never should have resigned. She can do what she wants in her own house. Why did you help her resign? I'm putting these in, they were using pretty bad words and stuff. So I put that up on the screen. And said, what do y'all think about that? You think I should have not represented this lady? But the white racists telling me that. You know what the discussion was? No, and everybody just sat there. Everybody's afraid to have a discussion nowadays. It's really kind of sad the way we used to have robust discussions in criminal law about fun issues, but nobody wants to talk about anything anymore because everybody's afraid. And, they should be because somebody may be recording it, and the next thing you know, it's all taken out of context, and you're having a discussion about what it means to be a lawyer and how we should regulate lawyers. But anyway, I would say that's the end of the war story. But 2 months ago, ODC filed public formal charges against this former judge to now take action on her law license for using the N-word in her house. Now we spoke and she said, that's wrong. What I did was wrong, but this is wrong. So Dane, let's fight the charges. So we got a hearing in December. I'm very excited about this. This is because
There's no 8.4 adoption in Louisiana, right?
Well, this is the allegation is that this is conduct that violates 8.4C, which is conduct prejudicial to the administration of justice. It's the catch-all. We don't have 8.4G, which is the anti-discrimination. But part of my defense is, even if we had 8.4G, this wouldn't violate it because 8.4G, for those of you all who don't, Judy is an ABA geek.
I'm not a past president.
Past president of the ABA. I know, but and I mean that in a very good way. But 8.4G is the ABA's controversial anti-discrimination provision, which says you cannot, if you're a lawyer in a jurisdiction that's adopted 8.4G, you cannot engage in conduct that constitutes harassment or discrimination in connection with the practice of law. That's the key language, right? So you can't go into your law office and say, there are a number of protected categories. Of course, you could guess race, gender, national origin, socioeconomic status. There are a bunch of them. So you can't in your law office say, some of you probably heard this when you all were younger. Hey, honey, nice skirt. From the old guy in the office. Oh, there I go. That would violate 8.4G, even though that was probably commonplace in the 70s and before. You can't. That violates 8.4G. That's harassment based on gender. And it's in connection with the practice of law because it's in a law office. Well, here, what former Judge O'Donnell said was in her home. It had nothing to do with the practice of law. So it wouldn't violate 8.4G, even if the Louisiana Supreme Court hadn't expressly rejected adopting 8.4G, which it did. And there is a provision in the Code of Judicial Conduct that says if a judge resigns before being disciplined, the matter can be referred to the Office of Disciplinary Counsel. You know what you expect, like, for example, if a judge stole money from the court judicial expense fund, they should be disbarred as a lawyer too, right? Because they're stealing money. But this is the key language. A judge can be, a lawyer can be disciplined for conduct as a judge if the conduct would be sanctionable for a lawyer to engage in. So that presents the issue squarely, which is if a lawyer uses a profanity in her living room on a Saturday morning, can action be taken against her law license? I think the answer to that is that's ridiculous. That's my view of the case. Now, it's not just her lawyer talking, that's me. Just because I find it offensive that the state is going to come into your living room and regulate profanities. Even profanities that are horrible. That's the most horrible profanity that exists now today. But it's still a profanity uttered in the living room. Now it was posted on the internet, but she had no idea that it was, she didn't do it purposefully or even knowingly. So, you know, there are all kinds of First Amendment issues there, but that's going to be an interesting precedent if the Louisiana Supreme Court says, yeah, she's subject to discipline for that. Lawyers are subject to discipline for doing that in their own homes. If we're going to have ODC in our living rooms, that's going to be
8.4G, just as a footnote, didn't even make it to the Louisiana Supreme Court, as I remember. It actually wasn't a rejection. It didn't make it past the committee, right? That they didn't even make a recommendation on 8.4G to get it to the Supreme Court. So
yes, I was on that committee.
Marta and you. And,
Yes, I was on that committee before I was kicked off.
no, I didn't-
No, that story next. So yeah, and the Supreme Court did discuss it. I mean, they told us that they discussed it,
Oh, they did.
but they decided to just wait and see what happened in others.
In Pennsylvania's under review right now.
Yeah, a Pennsylvania district judge had found it unconstitutional,
New
and
Jersey's.
yeah, so interesting times.
Because it violates First Amendment.
Yeah.
Yeah.
But you know, at least there, it's expressly linked to law practice.
This language was shrunk down.
Yeah. So
No, yeah, even more so in New Jersey, it's been shrunk down further, I believe, that they don't.
Yeah, I'm not
get it
sure.
to Louisiana, I mean, but
yeah. So in any event, that's all quite interesting. But on the First Amendment issue, I represented a lawyer in New Orleans in challenging the mandatory bar membership in Louisiana. A guy named Randy Boudreaux, great plaintiff for this, but we sued the Louisiana Bar and the Louisiana Supreme Court, arguing that the First Amendment should prohibit the state from requiring lawyers to be members of the bar in order to get an occupational license to practice law. The argument is that under the First Amendment, you've got an associational right, you've got a freedom to associate with whom you want and to not associate with whoever you don't want to associate with. First Amendment means. Now, so that's kind of the big associational challenge, which really has been foreclosed by some old US Supreme Court opinions. And the thinking was, at least on that, was, I don't want to get into the First Amendment law on it. We expected to lose on those big challenges because of these long-standing Supreme Court precedents. But those long-standing Supreme Court precedents were based on other cases that have been since overruled in union cases. So we were really just kind of setting it up for the Supreme Court review. But meanwhile, we had a smaller challenge, which is that the Louisiana State Bar Association was involved in speech that that was ideological in nature. Like, for example, the Louisiana State Bar Association was taking positions on gun control, the death penalty, school curriculum, and a bunch of like 20 or 30 other things that really had nothing to do with lawyering, like tort reform. Lawyers do tort work, but the Louisiana State Bar Association was opposing tort reform. So it's okay for the ABA to do all this. They're a voluntary association. They take positions on all kinds of things, and that's fine. But this is a mandatory bar. So the argument was, put aside the large associational challenge. Here, the Louisiana State Bar Association that I'm forced to be a member of, or Randy is forced to be a member of, is engaged in speech he doesn't agree with. So he shouldn't be forced to join that organization because of the speech that they're engaged in that's unrelated to the practice. So that was the argument.
So I think I'm being a little dense on this. He can practice law. So if they say he can't even practice law without being a member of the association?
Yes,
So
that's the way it is in
he passed the
Louisiana.
bar, he got his license, but he can't practice law if he doesn't join. I don't remember, but that's what.
Yes, that's the law in Louisiana, and about maybe 19 or 20 other states. I forget what the number is. But some states have voluntary bars, some states have mandatory bars. Louisiana is a mandatory bar state. So that was the argument. Well, so we filed a lawsuit, then the Louisiana State Bar Association changed all the rules. And which was good. They said, we're no longer going to engage in any lobbying. We're not going to engage in any speech about non-lawyer related stuff. Terrific. But then they still, meanwhile, the case, we lose before Judge Afric. It goes to the Fifth Circuit. The Fifth Circuit reverses Judge Afric, sends it back to him for trial. And the Fifth Circuit says, well, here the plaintiffs have alleged that the Bar Association is engaged in non-germane speech. That's the buzzword. It's speech that's not germane to the practice of law.
Or the administration of justice.
Or that's right. You can
It's broader.
getting counsel for people, those sorts of things, about access to justice. That's okay. But this is, tort reform, school curriculum, gun control, death penalty, all that's non-germane to the practice of law. Therefore, Randy, you may be able to quit the Bar Association and still be able to practice law. So it gets remanded to Afric. We have a trial maybe 3 months ago, and part of the bar's argument was, well, we don't do this anymore. Look, Judge, we changed all of our rules. We're like, yes, they did. Very good, but they're still doing some things. They were still putting out tweets every week, like tweets like you should eat broccoli on Wellness Wednesday. You should go to the Red Mass with church. You should, they had a lot of tweets that we said, look, I eat broccoli. I like broccoli. I like blueberries. They want blueberries, but this is not germane to the practice of law. So we tried the case before Afric. We lost it. We would. So now we're back. Our briefs will be next week before the Fifth Circuit. And, who knows? We could have paneled with Judge Ho on it, or some of these good, First Amendment absolutists will probably win, but who knows? But that's where that case is. Now back to the war story is the Louisiana State Bar Association, when I sued them, decided that I couldn't serve on any committee anymore, so they kicked me off that committee, and they don't let me do so. Which is fine. I got plenty of other things to do, but I just found it interesting that the State Bar Association says you've got to pay dues to get your occupational license, but you can't do our stuff because we don't like what you said. Another little First Amendment issue there. I was thinking about suing it, but I just don't have this time. I'd win that suit. What you think? I mean, I'm forced to join the Bar Association, but I can't participate because they don't like the content of my speech. So, in any event. All right. Well, back to social media. That's enough about social media. Let's see what else we got. This is something that's come up. This is most recently from an advisory opinion out of a bar association about reply to all. This is another 4.2 issue. We all are on these huge email chains, and the question is, if I'm a lawyer and I copy my client on an email to opposing counsel, can opposing counsel hit reply to all and then copy the response that she makes to not only me, but also to my client? The answer is no. Every ethics opinion that's come out on this is no. That is a communication that violates 4.2 because you're talking to that client by that email. The argument in opposition was, well, you know, I must be authorized by the lawyer because the lawyer CC'd rather than BCCing the client. And the ethics opinions, and there have been at least 2 or 3 of them by now, say no, you can't do it, which kind of puts the onus on all of us to look at. We should be doing this anyway, looking at who this reply to all is really going to. And a good best practice is always to put your client in the BCC line, always. That way that nobody can accidentally reply to all of your client, because that's the way BCC lines work. So again, this advisory opinion is just another one that says, on the sender side, put your client in the BCC, and on the recipient replier, make sure you're not replying to clients. You know, this is something that comes up every now and again. And the only reason I think Claire and I did this post recently was because there was a disciplinary case from June where this came up. You know, some lawyers are like, you know, and I do this occasionally if I'm co-counsel with somebody, I say, yeah, look, just sign my name to it. Is that okay? Well, the short answer is yes, that's okay. It is okay. And there were some judges, I remember years ago, long time ago, Judge Tobias screamed at me over this, said, you can't do that. And I just still remember that. And he also said that you can't stamp names. You have to use a real ink pen. Did you ever have that?
Yeah, and he was a stickler on that, because I just remember, I never had a K, but I remember he would, you know, he was a stickler on interrogatory answers and everything, you know.
Yeah, and he called, I think he might have called me out for a stamp. And this is back when they were, hey Dean, when the first time kind of PDF stamps just came out. I'm not talking about some kind of, you know, rubber stamp, because I never had one of those rubber stamps, but a lot of lawyers did back in the 70s and the 80s. But when PDF stamps first came out, Judge Tobias' position was you can't put that on because that's not really a signature, because you have to use a pen. I never really got that. But this case is just interesting because it said, it made it very clear that yes, there's nothing wrong with you signing another lawyer's name as long as you have actual authority to do it, and it's not, you know, then it's not a problem at all. You know, this is something that comes up fairly often is, and I got a call from a lawyer last week, actually. This blog post dates back to the summer, but where the lawyer says, you know, I just found out I missed a prescription date. My case, the client's case is prescribed. Thankfully, it's only a 1530 policy case, so it's not a big case, but do I have to self-report to the Office of Disciplinary Counsel? And the self-report question is another question that I get all the time, mostly on Monday mornings after, you know, I got DWR this weekend and Bunky. Do I have to self-report? Well, first of all, in the legal malpractice, the Office of Disciplinary Counsel says lawyers make mistakes. It's not sanctionable as a matter of a violation of Rule 1.1, 1.3, which are the rules on competence and diligence, for you to miss a prescription date or just commit routine malpractice. What they do, though, is they do go after lawyers if they not only malpractice, but also have, they call it malpractice plus. So some of the pluses that we've seen, of course, are the lawyers who don't tell their clients that they malpracticed and hope that the preemptive period runs and they never get sued. That's a plus. Lying to the client about what happened and why it happened, that's a plus. Some lawyers have even ginned up orders dismissing the client's cases to say, oh, look, we lost. And that's a bad plus, obviously. Yeah. Well, lawyers are pretty creative sometimes. So again, that's the long and short of that, is that just plain old malpractice. It's not going to subject you to discipline. Malpractice plus will. Now, on the self-report issue, Justice Crichton on the Louisiana Supreme Court, and I do a CLA with him for the Judicial Conference every year in December, and I'm doing it again with him in December. And I always get the opportunity to tell him about all of his opinions. He does lots of concurrence sense for some reason that I disagree with. He's very good natured about it and enjoys the discussion. But he had a concurrence or a dissent last year where he faulted a lawyer for not reporting himself for some act of misconduct. And none of the other justices faulted the guy for it, but he in his concurrence said, look, I think Rule 8.3, and this is the ABA version and Louisiana version, says that you have an obligation to report the misconduct of another lawyer. Well, you are not another lawyer, you are yourself. So you do not have an obligation, and this is my Monday morning talk on the telephones. You do not have an obligation to report yourself if you've committed misconduct. And it also maybe be some Fifth Amendment issues if you've done something criminal that you can't be forced to call your state and say, hello, state, I've committed a crime. You don't, there are Fifth Amendment issues as well, but just as a matter of the kind of reading of the text of Rule 8.3, you do not have an obligation to report your own misconduct. And now, sometimes lawyers should, like namely, this is stuff from grade school, right? If you're going to get caught, you might as well report yourself because you'll get a half a brownie point for report. So that as a prudential matter, it's sometimes. It used to be, and some of us here are old enough to remember it, back in the 80s and 90s, before there were computers, people would get a DWI or get arrested for something, and nobody ever found out about it. Then for a while, they were reporting the DWIs in the newspaper. You remember that? In the Times-Picayune, they'd have a list of all the people who got arrested for DWI. And then, sometimes, lawyers' friends would see it and call and report the lawyers to the Office of Disciplinary Counsel, and that would open files at ODC. Now, what happens is Chuck Platzmeyer, the Chief Disciplinary Counsel, goes around to the DA's offices and gives them CLEs, but he always says, look, if you see lawyers, with DWIs, domestic violence, you name it, please turn them in to me, because I collect those names, so please turn them in. So he's getting more reports from DAs. And also, the people in Baton Rouge who give you a hardship license, I don't even know how this works, but if you get a DWI, you don't blow, they revoke your license, but you can go get a temporary license. If you demonstrate that you have hardship, you need to drive to work, they'll give you a temporary license. Well, those people, the minute you say you're a lawyer and you need a temporary license to drive to work, they report you to ODC. So I'm finding about 90% of the lawyers who get DWIs these days get reported to ODC. But there's still 10%, who don't. So that's why I always tell the lawyers, you don't have to report, you shouldn't report, and then we'll just see what happens. And 90% of the time they get reported anyway. Let's see. Yeah, this was interesting. This was something out of Texas from about a year ago that was bad advice, and I'm not even going to get into it, but if your client, you're sitting there at a deposition, your client lies about a material fact, under Rule 3.3, the thinking is that you've got an obligation to take reasonable remedial measures because your client has lied. Well, some people say, well, it's a deposition, it's not in court. Well, no, depositions are as if we are in court. I know there's no judge there, there's no jury, but they are treated. And that is pretty much universal in all the ethics and disciplinary opinions, is that you lie at a deposition, same as a lie in court. So Rule 3.3A gives you the obligation to take reasonable measures. So that is is pretty settled, even though that still surprises some lawyers when I tell them that. Now, in Texas, their rule is a little odd. Is a little, are you up next?
I'm
Oh. Thank you. In Texas, apparently, if somebody lies, but you're not asking the questions, you don't have to do anything about it. That's what I said. What? But in Louisiana, I know the ABA rules, if it's your client or your witness, not that we vouch for clients or witnesses, but under 3.3, if it's your client or your witness, you have an obligation to take those remedial measures. And that is, well, it depends. I mean, the comment says you start off by, and this is a word you don't use in conversation, by remonstrating in private with your client, which is, I think, taking it back and saying, you know, what have you done? You got to fix it.
But so if they come back and tell the truth, are they then charged with perjury? I mean, how does that?
You know, that's a good question. I've got that in a bar admissions case right now where my client went and during the deposition and said, look, I didn't do that. They're like, hey, let's stop. Go back in. He goes, you know, I did all that. I did do that. Fixed it within 15 minutes, right? I think, you know, you fixed it.
I used to be a prosecutor. I would never do that.
Yeah, I mean, I think you fixed it, but no, they're like, you know, it's a lie. Boom, you can never fix that. It's done. It's out there.
Oh,
I don't know. So I don't know the answer to that question. I really wish I did, but I think if you take it back right away, it should be okay. But I'm a
so
soft,
you have the 15
softy, but
3 seconds are like food.
But can you just correct your deposition when you reviewed it and correct it and say, oh, I didn't understand.
right. Technically, errata is supposed to be errata. It's not supposed to be changing the
Right.
no to yes.
Yes.
That's a substantive change in your testimony. It's not supposed to be about that, but you know, we've all seen clients do that. But you know, that's another thing that really comes up in these bar admissions cases a lot, is that how do you, because one of the considerations is, have you rehabilitated yourself from whatever it is that caused us to deny you admission last year? And if you had a drug or alcohol problem, it's easy, right? I've got a JLab contract now. I'm on the road to recovery. I'm sober for, that's easy. But if you lied on your bar application or on your law school application, or you cheated on a law school exam, I mean, all these things come up every year for somebody. How do you ever, and the justices always say, how do you rehabilitate from that? And they've never answered that question, but it all kind of, what it means is they just basically want you to have some pain for a few years by sitting out watching all your friends work. And after a couple of years of pain, then they'll let you back in. They'll let you in, not back in, they'll let you in. And also the same thing for readmissions and reinstatements and disciplinary. It's always, how do you rehabilitate from lies? There's no good answer for that. Part of it is saying, hey, I lied. That was a terrible mistake. What I did is wrong, wrong, wrong. I lied. That was a lie. Say it over and over again. Like that.
A little bit off point, but I don't know if Tulane has this rule or not, but looking at all this with my daughter, as a 3L, they have a Halloween party coming up at her law school. And she actually has to sign a document before she attends. And saying that she will be involved in no activity, which would be any activity that would be, you know, against their code, but also in essence would be affect her bar admissions sort of thing. So,
Wow.
and she's thinking costume. No, what?
Yeah, there's a lot.
It's really, I've never heard of that before.
I don't know. It's behavior. It's behavior conduct
We
based.
do a lot of remonstrating.
Yeah, and there's a lot of costume stupidity going on out there too. Yeah, I mean, in fact, we had a judge disciplined in Louisiana, Judge Ellender, maybe 5-6 years ago, or again, like probably 20 years. for wearing a terrible, terrible Halloween costume. So, yeah, that's a good way to end.
Can you ask one more
the eve
question?
of Halloween, almost.
It's so interesting, the recent, and I couldn't read I didn't go read the whole article, but that recent article on attorney-client privilege expectations, or with regard to giving something to a print shop or to, did you see that, a new opinion on that? A new case on that? Not Louisiana, but it was
Yeah,
was that like at a hotel? And
I,
somebody asked somebody to copy something or something, I couldn't tell. And expectation of.
I don't
confidentiality.
remember it, but that probably goes back to the 1.6C conversation we had earlier, which is what's reasonable under the circumstances. And I mean, we all take documents to Kinko's
Right.
and we let people copy things. So, you know, again, I don't know what's reasonable or not. But, you know, by and large, most people aren't interested in what your answers to interrogatories say. It's kind of boring stuff. What they're really interested in hacking and stealing are social security numbers and stuff, interesting stuff. So I don't know the answer to that. It really just depends on all the circumstances. All right. Well, thank you all very much for having me.